I apologize, but I'm emotional.
Well, don't get emotional. It's a sad thing, but I need facts and information.
We went to the same high school, played on the same high school basketball team.
You're not paying attention to me, sir.
This is Judy Justice. Marquis Marshall and Kai Booker are suing their former employer, Gary Zephyrin, for unpaid wages.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case number 2071, Booker Marshall versus Zephyrin.
Thank you.
You're welcome.
Zephyrin?
Yes, ma'am.
Mr. Zephyrin, you're being sued by these two people because they say they worked for you delivering packages, I believe, of auto parts. Is that right?
Yes, Judge.
And you didn't pay them. That's simple. You're in the auto parts business or just the delivery business?
Just the delivery business.
For how long?
For about a year.
Explain the business to me, since you're not in the auto parts business, just the delivery business. I have to understand the process and keep it short.
The process is I go to the store, pick up the car parts.
Go to what store?
Hyundai or Toyota.
So you go to the manufacturer?
Yes.
Or the dealership?
The dealership.
And get the part?
And get the part and deliver it.
And you take them to independent garages that fix cars?
Yes.
Okay, now I understand. Your business is you're sort of a middle person between your local auto repair shop and the manufacturer who manufactures those parts or its dealer.
Yes, that's correct.
You don't make a markup on the part, you're just paid for your delivery service. Is that right?
Yes. I do not pay for the parts. All I do is drive and deliver the parts.
So the part has already been ordered and paid for?
Yes.
By the garage, by ABC Garage?
Yes.
They just send you to expedite the delivery?
Yes, ma'am.
And how much do you get paid for each delivery?
Well, it's not by each delivery. At this particular contract, it was between $120 and $160 a day.
And you said that this particular contract, what contract is that?
This is the car parts contract. Before the car parts, delivering the car parts, I was delivering packages.
But this operation was just car parts?
Yes, it was.
Now, at some point, these two people, how many vans do you have that deliver the parts?
Currently, I have one van.
What were they using to deliver the parts?
The van that I have.
And what did you do?
I worked in my 9 to 5.
You had a different job?
Yes.
What kind of job did you have?
I work at the Navy Yard.
So this is sort of a side gig?
A hobby, I would say.
Well, a hobby, $120, $160 a day is a nice hobby.
I think so.
Yeah, okay. And so based upon what you told me before, both of these people did in fact deliver parts using your van to various ABC garages.
They also used it for personal use too, yes.
I don't care, but they used it because you didn't use it. You were doing your day job, according to you.
Yes.
And this was a side gig where these two people were working during the day to deliver the parts.
Mr. Marshall was working during the day.
Okay, let's just say Mr. Marshall.
Okay.
Now, Mr. Marshall sort of contracted with Miss Booker, or did you?
Mr. Marshall did.
You contracted with her. You agreed with her that you would split up this delivery. You would do it a couple of days, and she would do it a couple of days.
Yes, Judge.
Okay, so you had no direct agreement with him. Miss Booker, look at me. My question is, did you have a direct agreement or ever meet or discuss salary with the defendant?
No, I did not discuss
And you
that.
can sit down.
Okay.
Because you have to have some sort of an agreement with someone in order to sue them. You had no agreement with him. Whatever agreement you had with him, correct? Is
Yes.
that right?
Yes.
And am I correct, Mr. Marshall, that you were supposed to be paid, according to you, a certain amount per day to make these deliveries? You decided you wanted to work 3 days a week and she would work 2?
Yes,
That's
ma'am.
what I thought I read. Okay. How much was the defendant supposed to pay you a day?
$80, Judge.
So you had a deal for between $120 and $160 a day. You were paying him $80. You were working your day job. And so you were either going to get $40 or $80, depending upon the work that was done, right?
Correct.
And you were going to get that as a result of his work.
Yes.
Perfect. Now, this is what you say. You say that you all decided to go into business together. You bought this van. You paid for the insurance. He was going to work and make the deliveries I'm telling you what you wrote.
Okay.
And if you have a problem with that, you'll tell me in a minute.
Okay.
He was supposed to work, make the deliveries, and not get paid until you paid off all your expenses, your startup expenses, the van, your insurance. Didn't you say that to me?
Yes, I
Or
did.
maybe I'm thinking about another case.
I did say
You
that.
did say that to me.
I just wasn't correct the we, because I bought the van and I paid up all the stock.
I said you paid. I didn't say he paid. You paid the van. You paid for the insurance. He was going to drive. He says you were supposed to pay him $80 a day to do that because you had a full-time job. You were making your money. Your defense to it is that that was not the agreement. The agreement was that he would work for free until all the expenses were paid off that you advanced for the little business.
Yes.
Right?
Yes.
How much was the van?
$2,000.
So it was an old van.
Yes.
And how many months did you work at this job before you had a kerfuffle with him?
A year and 3 months.
Is that correct, sir, that he worked a year and 3 months?
It seems more about close to a year to me.
And when you say you worked for a year, was that 52 weeks a year?
Yes.
5 days a week?
Yes. Sometimes on Saturday.
From when to when?
I would work, depending
No,
on...
from what month and year to what month and year?
January 2021 until March or April 2022.
And in that year plus, how much money did you make? If you kept records of the days that you worked and how many hours you worked and how much you were supposed to be paid, then I could look at that. But I can't do this. This is ridiculous.
Judge, may I explain?
You can try, but you're going to be unsuccessful, Mr. Marshall, but I'm going to give you an opportunity to try.
And later today,
He did, in fact, bring you a truck.
He didn't.
Never brought you a truck.
Never brought me the truck, never returned my money, anything.
Oh.
Marquis Marshall and Kai Booker claim their former employer, Gary Zephyrin, owes for unpaid contractor work.
Okay. In that year plus, how much money did you make?
Judge, it's a tough question because Mr. Zephyrin never paid me what he was supposed to pay me. He always came up with an excuse or a reason why.
I want to know how much money you made in that year.
I don't know off the top of my head.
Well,
Judge.
then I can't help you. I have to know how much money he paid you, and I'm going to figure out from how much money he paid you, because even if I buy his defense, the van was only $2,000. So you have to sit down and figure out how much, unless you know, how much did you pay him?
Around $320 a week.
What do you mean around? I mean, you're a businessman.
He did not work 5 days a week. He's saying he worked 4 to 6 days a week. All he worked was 3 to 5 days a week.
I assume you were paid in cash,
Yes.
but you were paid during that year.
Yes.
Give me an idea in thousands how much you were paid.
Around $20,000.
$20,000.
Yes, Judge.
Around.
Yes, Judge.
So he did, in fact, pay you.
He didn't pay me everything he was supposed to pay me, Judge.
Well, how am I supposed to figure that out, sir? How am I supposed to figure that out? You keep records of what you delivered? Does he keep records? He doesn't have to prove your case. You have to prove your case.
Yes, Judge.
So do you keep records of when you worked and when you were paid?
Yes, I keep records of when I worked, Judge, but I did not keep records of what I was paid because we're always arguing. He never paid me the full
Well,
$700.
that's not the reason you don't keep records. I'm sorry, Mr. Marshall. If you kept records of the days that you worked and how many hours you worked and how much you were supposed to be paid, then I could look at that. And I can ask him, and I assume he's a businessman. He would have the same records, and there may be a dispute, but I can't do this. This is ridiculous.
Judge, may I explain?
You can try, but you're going to be unsuccessful, Mr. Marshall, but I'm going to give you an opportunity to try.
I appreciate it, Your Honor. Mr. Zephyrin was my friend. We went to the same high school, played on the same high school basketball team. I was the MVP, he was the team captain. Recently, his health has been declining. Because his health has been declining a year ago, I went to Mr. Zephyrin and I said, I'm a private contractor and I have different contracts with places. I think that you should do private contracts so you can spend more time with your kids and your wife. I apologize, but I'm emotional.
Well, don't get emotional.
I used to love
Mr. Marshall.
this gentleman.
Mr. Marshall, what I'm telling you is don't get emotional. This is not...
Okay.
It's a sad thing that you know each other for a long time, I hear, and that it's come down to a case in court. But you have to understand that in order for me to make a judgment, I need facts and information. And it's not as if you're saying to me that you delivered packages, which he acknowledges, and you were never paid. What you say is that you were shortchanged.
Yes, Judge.
And you have to be able to show me that.
I have the agreement of Mr. Zephyrin agreeing to pay me the $80 a day, and we came out with a pay
Just
scale.
a second. That's okay. I have to see when you worked and what you were paid. How am I supposed to figure out what it is that he owes you?
Because we both know that he only paid me $300 instead of the $700. We both know that.
Well, he paid you $20,000, so that's not true. According to you, he paid you $20,000. So if what you're saying that he paid you $300 and he owed you $700, is that what you're saying to me?
Yes.
Okay, so it was the last period of time that you worked for him?
Yes.
Okay, so that last period of time was when to when? Give me the month, give me the day.
January to March this year.
From January to March
Yes, Judge.
of 2022,
Yes, Judge.
you worked and you claim you were owed $700. That's what you just said. Is that correct?
I apologize for the
He
miscommunication,
said-
Judge. He only paid me $3 when he was supposed
just-
to pay me $7.
Just a second. You're not paying attention to me, sir. I said your claim is that he owed you $700.
He owes me more than $700.
No.
Judge.
What you said was he owed me $700 and he only paid me $300. Could you
Correct.
read that
yes.
back?
Yes.
Could you
yes,
read
Judge.
that?
Yes, Judge. You're correct, Judge.
Okay, then we don't have to read it back. That's why I have Whitney. You said he owed me $7, he only paid me $3, which means he owes you $400.
Correct, Judge.
And that was from a January to a March.
Yes, Judge.
Okay. Do you have any records of that, sir?
I paid him in cash, so I don't have any records of the payments that I was paying him. Mr. Marshall, he really never wanted me to keep records.
Okay, don't tell me what he wants. It's your business. Don't be foolish, sir. Did you have a dispute with him over this $400?
I did. We had many disputes.
Okay. Did you, in those disputes, refer to a part that got misdelivered by either the plaintiff or the person who he subcontracted with that caused you to lose a customer?
Yes.
Okay. And was that the reason that you didn't give him the $400? Just listen to my question. You had a dispute after all this time over a part, according to your answer, that was misdelivered to a customer,
Yes.
which caused you, according to you, to lose the customer. I don't know that, but that you indicated was the reason that this arrangement went south. So my question to you is that why you didn't pay him the $400?
No, it's not. He didn't return my van.
Oh, so the reason you didn't pay him the $400 that you acknowledged that you owe him was because he kept your van.
And my contract was canceled due
Okay.
to Cab Booker.
Okay. Did you get your van back?
Yes, I did.
How many days later?
2 days later, after I threatened to call the police.
Okay, you owe him the $400, sir. Judgment for the plaintiff in the amount of $400. We're finished. Thank you.
This court is adjourned.
You can't keep somebody's van for 48 hours and still expect your money.
He's lying about the fact that we stole the van and that we had it for those 2 days.
I think it was really bad that he's suing me over this. We've been friends since high school.
Document everything that you do when you do it. That would make better sense.
But hey, things happen. He got a new girlfriend and things happen.
Not a difficult situation. If you choose to pay an employee in cash, you have to keep records. Both parties should have kept some sort of records. Otherwise, what they were asking me to do was guess. This defendant actually made it easy for me because without his statement, I would have dismissed the case. He said the reason he kept the $400 because the plaintiff did not return his van right away, kept it for 2 days. Well, that's sort of retaliatory. How do you fix $400 as
Cost for keeping
as a
the
cost?
van.
You know, that's ridiculous. That's self-help. Keep records,
You should.
especially if you want to come to court.
Exactly.
Case number 2075, Johnson versus McIntosh. All parties, please step forward.
Dominique Johnson is suing her children's uncle, Chris McIntosh, for a truck she never received.
Miss Johnson, this is your brother-in-law. I believe that, is it your husband or is he your ex-husband?
No, it's just my kid's father.
Okay. The father of your children is currently incarcerated?
Yes.
So he's not your brother-in-law, he's just the brother
Yes.
of the father of your children?
Yes.
Okay, you have 2 children?
I have 3.
Is he the uncle of all 3?
Yes.
Okay. There came a time when you were in need of a new vehicle or a different vehicle. Your car was giving you trouble.
Yes.
Mr. McIntosh, according to what I've read, has tried to maintain a relationship with his brother's children.
Yes.
Despite the fact that you no longer have a relationship with him.
Yes.
And according to what I'm putting together, you reached out to him or you were on the phone with him and told him you needed another car.
Yes.
And according to you, he said he had a car, a truck.
Yes.
That he would sell you for $2,700.
Yes, that he would personally bring to me.
And he did, in fact, bring you a truck.
He didn't.
So on what date did you buy it?
I don't.
Think. You know, you're coming to court today. You knew that this was the issue when you came here.
Yeah.
Not yeah, yes.
Dominique Johnson claims her children's uncle, Chris McIntosh, owes for the cost of a truck she never received.
According to you, he said he had a car, a truck,
Yes.
that he would sell you for $2,700.
Yes, that he would personally bring to me.
And he did, in fact, bring you a truck.
He didn't.
Never brought you a truck.
Never brought me the truck, never returned my money, anything.
Oh.
I even tried
Just a second.
Okay.
So you sent him the $2,700.
Yes.
What date?
June 21st of this year.
What happened to her $2,700?
Bought the truck there and then dropped it
What
off.
truck did you bring there?
2007 Suburban.
And where did you get that truck from?
I got it from an auction.
Okay, I'd like to see the paperwork.
I don't have the paperwork.
Well, that's unfortunate. Why wouldn't you bring the paperwork? It's only a couple of months ago.
Because the auction is every first Thursday. It's not the same person running the same auction. They don't have the same paperwork for the auction.
Well, if you had paperwork, you would have also have had a title for it.
Yeah, and I left it in the glove compartment box.
What's the name of the auction?
Towing,
Where are they located?
Minneapolis, Minnesota.
Sarah Rose, would you look that up, please? She did send you the money.
Correct.
How did she send it to you?
Cash App.
Yep, which I have proof, Your Honor.
No, there's only one issue. She says that you never brought any truck. You say, well, you bought this truck at an auction. The auction is every Thursday?
Every first Thursday of the month.
First Thursday. So on what date did you buy it?
I don't.
Think. You know, you're coming to court today. You knew that this was the issue when you came here.
Yeah.
Not yeah, yes. So what date was it that you bought the truck, that you have no paperwork
Thursday.
for at all?
Thursday.
Which Thursday?
What month was that I bought you the truck? I really don't know. Like, I'm being so serious like right now. Like,
Honestly, if I could speak, it was June 21st I sent him the money. June 21st was when he was supposed to bring the truck to me. He never bought the truck. Then he stated to me that he sold the truck and that he had another one that was less, and I have that truck as well. This was the first truck initially I was supposed to get.
Did he ever bring you any truck?
No, not at all.
Do you have any phone messages?
I do.
I'd like to see them, please.
And towing. It's a towing and auction house.
Okay, say when they have auctions.
It doesn't list it on their website, but I could try and see.
It's a lot of them, honestly, a lot of messages.
I have those dates of the auction. They list their past auctions. There was one May 5th of this year, June 5th of this year, July 2nd, August 6th, and September 3rd of this year.
June
all the
what?
most recent. June 5th. And I actually have a list of every car that was included in that June 5th auction. So if you give me the make and model, I could see if it was included in that auction on June 5th.
You went in June for the auction or in July?
yeah, June 5th.
He said a 2007 Yukon, right?
No, Suburban.
2007 Suburban.
There was actually two different trucks that.
Well, that's the one he said he bought.
The only car from 2007 at the June 5th auction was a 2007 Nissan Murano.
Nissan Murano. Wasn't a Nissan Murano. That was the only one that was sold in June 2007.
It was sold in 2007, but I bought a 07 Tahoe Suburban.
I understand that.
from
But you
that
say you
auction
bought it in
place, so-
June, and they list on the website everything that they sold in the June auction. Am I understanding that
Yes.
right, Sarah?
Yes.
They list all the cars that they sold in the June auction. And the only car that they sold that was a 2007 was a Murano. He says, and I will be leaving in about an hour or two after I get the Venmo. Would you please just put where you start to ask for your money back because you didn't get the truck? That's what I want to see. I want my money back because you didn't bring me the truck.
There was no Chevy Tahoe 2007 at the July 2nd auction.
Either.
And a lot of the vehicles, a select few, are above $1,500, and that's for newer models. Everything else is under $950.
Thank you. There was no such car either in June or July.
No.
Okay. That's so interesting that they have that information on a website. Ms. Johnson, you can't just give me your phone and expect me to go through
Yeah, I
pages.
apologize.
All I want, you said you had something indicating that you told him you wanted your money back because you didn't get a truck. So far, there's no evidence that he bought you a truck from the place that he said he bought you a truck.
Yep, here's the part where I'm asking for the money back. He doesn't have proof that he even bought the truck.
No, there is no proof that he bought the truck.
He never bought the truck. Okay, so starting from here, this is me asking if he wanted to just cash at me back my money because he never showed up.
Read it to me.
Oh, okay. It says, do you want to just cash at me back the whole $2,700 because all this waiting isn't necessary. It's just a few taps to cash at me back my money. We can say forget the whole thing because now this isn't sitting well with me. This was supposed to be easy. I don't have my truck or my money. Like, how does that work? And then I offered to just go down there and get it myself. And then he said that there was no place. I said, okay, but how do I get it home with no place? So this whole time he was kind of dragging me on. And then this is the picture of another truck that he sent me.
That's a picture of him.
Yeah, he's posing in front of the truck, the second truck he supposedly had bought for me.
At the auction, yeah. He just told me he bought the second truck at an auction. There's no indication that that auction house where he said he bought it sold a truck that he said that he bought, either in June or July. Got that right?
Yes.
Okay, I don't have to waste any more time. You have no paperwork, Mr. McIntosh, that you bought this truck. You have no proof at all that you brought this phantom truck to her house. Why would she be asking for her money back?
Because I bought her a truck and I dropped it off in front of her house, left her the paperwork saying what's wrong with the truck in the truck. She says that she didn't want it, so I said my finder's fee was only like $400, and that's $200 for just a bus ticket to get there. She can sell the truck and get her money back. That's what I told her.
$2,700, judgment for the plaintiff. Thank you very much.
This court is adjourned.
I hope this don't affect the relationship with my nieces and nephew.
I'm not really here to bad talk anybody. I just wanted, my money back.
I left it there with the papers and the receipts.
Right is right, wrong is wrong.
She said she didn't want it. I told her she can sell it back, get her money back.
I feel like he kind of screwed it up in a way.
I just want to be a good uncle all the time.
I love when a website is so meticulous and gives us all the evidence that we need. This website had a very well planned out photos.
Towing company.
Towing and auctioneer house had every single auction, every car that was sold, photos, the username of the person who purchased it, and the price of the vehicle.
I can't imagine a company like that doing that voluntarily. And it has to be by law to be licensed in order to avoid stolen cars being auctioned off. Has to be very smart.
Yeah, good way to track the evidence.
That was impressive.
Yeah.
Thank you.
Of course.
You lived with him in his home.
Yes, ma'am.
There was a dispute.
I received partial or no rent payments.
As a result of this harassment?
That's correct.
Ridiculous. Do you know my husband harasses me every day?
This is Judy Justice. Mark Michelonis is suing his former roommate, Christopher Robertson, for rent, a security deposit, and stolen property.
Court come to order. All rise.
Have a seat, please.
Hello, Judge. Case 2066, Michelonius versus Robertson.
Thank you.
You're welcome.
Mr. Robertson, how long had you been living in your apartment prior to renting a room to the plaintiff?
I believe it was about 3 years.
You had been living there by yourself?
No, I had roommates previously.
When did the plaintiff move in?
I believe that it was January 1st of 2017.
2017?
It may have been 2018. It was the first, I forget.
It was 2018.
That's correct.
How long did he live there with you?
He lived there with me until September of 2021.
So far, that correct, sir?
Yes, ma'am.
So now let me understand this lawsuit. Mr. Robertson lived in his apartment for 3 years. You answered an ad for a room. You lived with him in his home as a tenant from January 2018 until September 2021.
Correct.
At that time, there was a dispute. Probably we'll get into that in a moment. There was a dispute. During part of that time, Mr. Michelonis, you did not pay rent. Is that correct? During COVID?
That's correct.
For what period of time did you not pay rent?
Well, there was,
Give me how many months you did not pay rent?
There was...
You don't have to think out loud. How many months between January of 2018 and September 2021 did you not pay rent? Give me a number. That's a number.
4 months. Some months I paid partial rent. But there were 4 months that I did not pay any rent.
4 months, no rent. And how many months did you pay partial rent?
I believe that would have been 4 or 3.
So for 7 months, you did not pay your rent. Paying partial rent is not rent. Now, my question to you, Mr. Robertson, is this is an apartment that you rent
Yes.
or rented. From January 2018 until September 2021, was your rent current?
My portion of the rent was current.
What do you mean your portion?
My portion that I was responsible for.
No, it's your apartment. You're responsible for the whole thing, Mr. Robertson.
Yes.
Okay? You're responsible for the whole rent. And if what you chose to do was to say to your landlord, listen, I have a roommate, I'm just paying my portion of the rent, my roommate isn't paying his,
Right.
then your rent wasn't paid.
Yes.
And I assume that your rent wasn't paid for the same period of time that he didn't pay you his portion of the rent.
Yes.
Was it for any period of time greater than that? Greater than the 4 months or the 7 months that he didn't pay rent?
I went through my bank statements, and they went back until, I believe, July of 2020, and that's as far back as my bank app lets me go.
Okay.
There were more months than that that I received partial or no rent payments for.
From him?
From him.
I'm asking you about your landlord. If you didn't pay your landlord, you telling me your landlord didn't file an eviction against you?
There were several months that he did pay his full rent, and so that would have meant that the entire rent for that period.
Well, I know, but if the rent was not paid, did your landlord ever serve you an eviction notice?
No, there was an eviction moratorium in Alameda County at that point for unpaid rents due to COVID.
Gotcha. So that would it be a fair statement that you both took advantage of that? He took advantage of it, and so did you.
I wouldn't say that it was me trying to take advantage. I would just say it was my inability to cover the entire rent.
Your portion as well as his.
My portion was always covered.
Your portion was covered.
Yes.
Okay. Now, Mr. Michelonis, when did you move from month and year?
It was September of 2021.
And when did you leave there?
I believe it was the 3rd or 4th week of August of 2021.
So you both left the place at about the same time.
I left involuntarily, but yes.
Well, you left involuntarily, because that's what this case is about. Okay, so now I have the structure of it. Do you understand the structure of it?
I understand.
You understand the structure of it? I just want to make sure that people out there watching understand the structure of it. So you were the rentor, and you had an argument. It resulted in a protective order for somehow some genius put him out of his own apartment because of these protective. You weren't in the hospital for anything, were you, as a result of an assault? No.
No.
You have no medical records there of being treated for any injury.
It was a harassment.
Just a minute. Do you know my husband harasses me every day? Every day. I couldn't think of evicting him. I mean, you do other things. So the answer is, you were never treated for any illness. You were never treated for anxiety at a hospital as a result of this harassment. As a result of your allegations, let us say of harassment, Mr. Robertson was ejected from his own home, from which you had not been paying rent, your portion that you were supposed to pay contractually with him for months because of COVID. Am I getting this story right so far? I'm not finished yet, but so far, is there anything that I said was wrong?
I think that's pretty close. I mean,
Okay, so that's pretty close. And now what you are seeking here is, should I say basically, and I hate that word, basically, but it's appropriate in this case. So all of those haters out there, she used basically, I don't care. It's appropriate here.
and I put in the protective order that they were living with me, but they were moving.
No. They were living with you. You were living with them.
Well, yeah, we were living together.
No. You were living with the defendant. He wasn't living with you.
Mark Michelonis claims his former roommate, Christopher Robertson, owes for rent, a security deposit, and stolen property. Christopher is countersuing, claiming Mark owes him for rent.
Now, what you're claiming in your lawsuit is that after a review of the copy of the underlying lease, you found that you were paying the vast majority of the rent.
Correct.
And so you want a return of that money.
That's correct.
Under what theory in the law?
Well, basically that he defrauded
No,
me.
now you can't use a basically.
Okay.
I want to know what theory is there in the law that says if I own a building and I lease to someone the whole building for $10,000, and then I find somebody who is prepared to pay me, and I have the first 2 floors of the building. 3rd floor is vacant. I find somebody who's willing to pay me $9,000 a month just for the top floor. That makes me a good business person. But unless there is something that prohibits him from doing that,
There is, Your Honor.
show me.
There's a clause in the lease.
No, just show me.
Okay.
I'm a lawyer. I can read a
So
lease.
the sublease that I agreed to with him incorporates the entirety of this master
Just a second,
lease.
I'd just like to see it,
Okay.
please, sir. I'd just like to see it. I assume you've highlighted what you want me to read.
Correct.
Okay. So what you're pointing to is that the landlord, his landlord, was not advised that you were subletting.
No.
Well, that's why signed by every tenant.
So that was one of the things, because if you look at the second lease, the one that was altered by Christopher to remove those areas so I wouldn't be aware, or I wouldn't be able to enforce them, was because he moved his boyfriend in without getting my consent. And so it says in there that he needs written consent. I understand that that doesn't apply to me, but he thought it did. And so he used whiteout on the other lease that I gave to you to obfuscate those terms.
I don't know how to put this to you, sir, other than to say, let me backtrack. What kind of work do you do?
I'm a web developer.
You work for yourself or for a company?
I do. I'm an independent contractor.
How long have you been doing that?
2 years.
Prior to that, what were you doing?
I was a system administrator
For whom?
for a small company in San Francisco.
How long did you work for them?
6 years.
So for 2 years, you were an independent web developer, and you're still an independent web developer.
Correct.
And that's how you support yourself.
Right.
So you work out of your home.
Right.
And you've been working out of your home, you said, the last 2 years since 2020. This is 2022 or 19.
Right.
What do you mean, right?
So it was yeah, it would have been.
When you
20
moved in 2018, were you an independent contractor?
No, I was going to school.
You were going to school?
Right.
For what?
When I went to,
Just
I
a
was
second, for what?
For web technologies. It was a program for web development technology.
Did you go in person?
Yes, it was an intensive.
For how long?
It was 3 months. It was 8 hours a day.
Okay, so you went to school for 3 months.
Right.
During what period of time?
January 2018 to end of March 2018.
Okay, and at that time you were living with the plaintiff?
Correct.
Okay, so you needed a room for that 3-month period. And after that time, you supported yourself by being your own boss, by developing websites for
It took
people.
me a while to find a job, but yes.
What do you mean it took you time to find a job?
The interview process to get work, I was interviewing, it was very hard to break into that industry.
And so what did you do?
So I started taking on independent work.
So you never actually got a job outside of the independent work that you did?
That's correct.
So you support yourself by doing web development out of your home?
Yes.
So you used the home that you were living in, that room that you were renting, for not only your personal business, but you operated a place of business out of your residence.
Okay.
What do you mean, okay?
Yes.
Yes. I just want you to see how ridiculous you are. You want $10,000 because you overpaid what you consider your fair share of the rent. That's not going to happen. You come here, you didn't pay rent for at least 7 months because of COVID. You were working according to you. You were a web developer, still are. It's 2022 because you have no other job other than being a web developer. You stopped paying rent. You moved out after he did, correct?
Well,
did you pay?
I'd like to correct
in the
something.
month that you lived there, when you had put him out of his house because you were
they were moving out. I did not put him out of the house.
I thought that was a protective order.
It was, but they were, and I put in the protective order that they were living with me, but they were moving, and so.
No. They were living with you. You were living with them.
Well, yeah, we were living together.
No. You were living with the defendant. He wasn't living with you. You were renting a place, although you weren't paying rent from him, and the underlying landlord wasn't getting his money, all of his money, because he wasn't getting your money. And what's coming to me is that somebody got stiffed with rent, and that would be the landlord who rented you your place where you were living, because you didn't pay him the whole thing. You didn't pay him the whole thing. And now you want me, you're asking me, to award you $10,000 for overpayment of rent.
Your Honor, could I clarify something? The times when I didn't pay rent, I was not working. It was during COVID, so the first couple months of the COVID lockdown, I lost all of my contracts, so I didn't have any money. And so using the COVID, there was a COVID process where you could, basically say that,
There's no basically in there, only I used it once.
So I did not have the money to pay rent. I was not just making money and not paying rent. I would not do that. I was broke. All of my contracts dried up because nobody had any money. I was working for small
So what are you
companies.
suing him for now? The government was very good to you. This is a very interesting America. It's a rent forgiveness, a rent moratorium. That doesn't mean the state where you live. What state do you live in?
California.
California. That doesn't mean the owner of this premises was given some sort of a break that they didn't have to pay for utilities, taxes, mortgage on the building, because it's used as a business. As far as I know, there wasn't a moratorium on that, but there was a moratorium on two seemingly able-bodied people to say to the landlord, I can't pay my rent. To add insult to injury, you think that I'm going to give you $10,000 because he charged you more than whatever the third or 40% of your occupancy of the apartment, and he shouldn't have? That's not going to happen, sir. So forget it. I've been here a long time. If a landlord is owed $5,000,
yes,
he doesn't say, well, tenant owes me $5,000, but his apartment was clean. I'm going to give him back his $2,000 security deposit. That doesn't happen.
Mark Michelonis has accused his former roommate, Christopher Robertson, of overcharging for rent and keeping his property. Christopher is countersuing Mark for unpaid rent.
Now, you gave him a security deposit. That is part of your lawsuit. Correct. So I want you to forget the overpayment of rent because it is ridiculous.
Okay.
So now let's go to the security deposit part of your complaint. Did he give you a security deposit?
He did, Your Honor.
Now, he didn't pay rent because of this moratorium
Yes.
on rent. Did you get your security deposit back from the landlord?
I did.
How much?
I believe I got the total amount for the entire apartment, which was approximately $2,000.
And how much did Mr. Michelonis give you as a security deposit?
He gave me $1,250 for the security deposit plus a $300 pet deposit.
Sometimes the pet deposit is refundable. Did you get the pet deposit back?
I don't recall specifically if I got that back from the landlord.
But you did get back your entire security deposit, which included his $1,250.
Yes.
Okay.
That's correct.
Let's hold that in abeyance for a moment, because now I'm going to go to your counterclaim.
Sure.
I think that's all I have to deal with. Oh, and property taken without permission. Did you get that property back? There was some...
I did not.
What property was it?
There was a stone Buddha carving. There was some dishes, some glasses.
Oh, give me a break. Do you have a stone Buddha carving?
I have the stone Buddha carving. I have a small statuette of a rooster that is his, and a small metal
Great. Would
serving
you
spoon set.
pack those up?
Yes.
Do you live close to each other?
I haven't been able to because of our mutual restraining orders.
Fine. Do you know where your local precinct is?
Yes.
Where is it located?
I believe that the closest one would be downtown for me, downtown Oakland.
Okay. You'll find out before you leave today. In 5 days, drop it off at the local precinct.
Absolutely.
Let him know when, and he could go pick up his Buddha.
Yes, I don't want
Great.
bad in my home.
Terrific. Now, money owed for COVID debt is your counterclaim.
Yes.
Which is what?
It is a total of $55.35, I believe.
For what?
That is the unpaid rent.
But you didn't pay his rent, you just told me.
Right, and so this is the outstanding balance of the rent that he never paid that I'm responsible for as the master tenant.
Oh, no, you just told me that you got your security deposit back. If you got your security deposit back, sir, that means that the landlord is finished with you.
According to the law...
Not according to the law. If you got your security deposit back, the entire security deposit, the landlord has written it off, because otherwise he would have taken your security deposit if you owed him or her money. Do you understand what I'm saying? It's very simple.
I understand what
you're saying. It's very simple.
I wish I could explain that to them in your...
Well...
in your manner.
I want to tell you something. I've been here a long time. If a landlord is owed $5,000,
yes,
he doesn't say, well, tenant owes me $5,000, but his apartment was clean. I'm going to give him back his $2,000 security deposit. That doesn't happen.
So
only in the land of Oz does that happen.
They might live there.
Not in... No, they might live there, but I don't live there. Okay. You owe him $1,250 for security deposit. This case is over. Your counterclaim's dismissed. We're finished. We're done.
Court is adjourned.
Thank you very much.
I would just like to bring
Bye.
Well, I was a little upset.
he's being a drama queen.
The clause in the lease was to prevent people from basically taking advantage of the fact that they've been living in a place for a long time and gouging rent for new tenants.
He said I was price gouging him because he was enough to pay more rent than he might have if he had done some more research.
They were trying to make it equal, and every place that I've lived in, there was always a equitable share of the rent. Like no one was ever gouging anybody. So I felt that I was unjustly charged.
Well, I can't say it wasn't very satisfying to hear the judge call his claims ridiculous to his face.
Basically, he was leaving the front door open, making it so my dog could escape easily. He was filling the house up with smoke.
We both burned sage.
He was basically trying to get me riled up. He wanted me to move.
While I am disappointed that I won't be able to recover some of his COVID debt.
Basically, the moment that he was, it was inconvenient for me to be there, he tried to make my life miserable.
I'm glad that I will never have to see him again, and this is done.
I'm not living with roommates ever again. I've got my dog, and we're cool.
He was a nightmare, and I never have to see him again.
Far be it from me to second guess another judge, but it would seem to me sort of outrageous unless there was some sort of a physical altercation. Why anyone, because he clearly was excluded from his house. He left first, and he said, involuntarily. Would anybody exclude
The original tenant.
the original
When I read the papers, I thought the same thing. I thought that was outrageous that they would throw out the primary leaseholder on a lease in favor of his subtenant, which may or may not have been legal to begin with.
I can understand it if there was something more serious, but harassment, I just don't understand it. But
I didn't.
Mine is not to wonder why. Mine is but to do what I do. And I don't think that when you come into a court where you have at least participated marginally in a giveaway, to then come in and say, you know what, there's a technical thing. He wasn't supposed to charge me this much rent because I didn't occupy this much of the apartment, whatever. Ridiculous when you didn't pay rent
Exactly.
for 7 months anyway. It made my job a lot easier. Saw his dog attack yours.
I was walking outside the back door, and then within like 2 seconds, I mauled him. He was crying, he was hurt, in a lot of pain.
Nope, this never happened.
I didn't hear anything. No yelping, no screaming, no nothing.
I don't care what you heard. Are you telling me both you and your father are idiots?
This is jute bills and an unlawful eviction.
Court come to order. All rise.
Be seated, please.
Hello, Judge. Case 1089, Eid versus Ferris. Welcome.
Mr. and Mrs. Eid, are you still living in the house where you were living and renting from the defendant?
We are.
And you're still living there after a decision by the housing court?
Correct.
Okay. Who owns the house? You do. And this is your dad?
Correct.
And you used to be friends?
Correct.
When you bought the house, and what year was that?
2020, so November 18th is when I closed on the house.
And the house is a multiple dwelling?
Correct.
How many families live in the house?
3.
You, the plaintiffs, and you rent to someone else. Is that right?
Correct.
And do the other people that you rent to have the same size apartment that the plaintiffs do?
Correct.
And what do you charge the other person for rent?
The unit upstairs is $900 a month.
And how much is your rent?
$875.
So you got a $25 a month friends discount.
Correct.
This case has to do with a dog.
Yes.
You have a small dog.
That's correct.
Your dog is a Chihuahua?
Correct.
And you have a larger dog. You have a larger dog.
Yes, Your Honor.
I have also 2 dogs myself.
Okay. What kind of dogs do you have?
They're both Akitas.
And your 2 dogs and the plaintiff's dogs, I assume since you were friends, get along?
They never really associated.
Well, that's not possible. I mean, I have dogs. I have a son that has big dogs. There are times when they're all together. They may not love each other, and the big dogs may say, I don't want this little one around me, and go into another room. But they've been together.
Correct.
Yes.
We've gone to the dog park together.
Yeah. So let's not think of what is good for your case. Let's just think about accuracy. Got it?
Correct.
Now, it is your claim that Mr. Farias was visiting with his daughter.
That's correct.
You don't live there.
No.
And he brought his dog for the visit. According to you, you and your dad were working, doing some renovations inside the house. The back door was open, and your dog is what kind of a dog?
A pit bull.
Okay. Now, Mr. Farias, has your dog ever been in contact with the plaintiff's dog?
No.
Was your dog inside with your daughter's 2 dogs?
Yes, Your Honor.
And they get along?
Yes, Your Honor.
And there's no question that you know that the plaintiffs are tenants of your daughters?
Yeah, I know that they're tenants of my daughters, yes.
Yes, of course. And it did say in your answer that you left the back door open so the dogs could go in and out freely.
Yes.
And you understood, Miss Farias, that your father's dog, while your 2 dogs had been in contact with the plaintiff's Chihuahua, his dog had not.
Yes.
You knew that. Now, this incident happened on April 18th of 2021.
That's correct.
And your dog, according to you, was injured on that day.
That is correct.
Tell me what happened.
So I was inside. I only heard the commotion. My husband was the one who witnessed it, so he would be more inept to describe it for you.
Right. So I was walking outside the back door. I saw her 2 Akitas out back.
So the 2 Akitas were outside?
Correct.
And is this backyard a fenced backyard?
Correct.
Don't show me pictures. It's a fenced yard.
Yes.
So you let your dog out with the 2 Akitas?
Correct.
Go ahead.
And then within like 2 seconds of walking down these 2 steps that go into my backyard, Mello came from the other side of like their apartment, but I didn't see him at all, and mauled them. It just happened so fast I can't get the image out of my head.
Did you ever see the father's dog before?
Yes.
Where?
At his house.
At his house or Miss Farias's house?
Both.
Both houses.
Both. When was the last time you saw Mr. Farias's dog?
At their house. We were there for an event.
When you say it,
No, he's been over to the new place since Michaela bought the house with Mello. So it might have been a month, a few weeks before.
Okay, but the 2 dogs had not been together.
Correct.
Correct.
So when you saw Mr. Farias's dog attack yours, you did what?
I screamed, Mello, drop him, Mello, drop him. And he dropped him after like the second or third time I did it. And then I picked up my dog, and that's when he snapped at my face because he was crying. He was hurt and in a lot of pain. And I went into my house, in my apartment, and
I met him right at the door.
She was right at the door because she wanted to know what was all the crying. And I told her what happened, that Mello attacked my dog. And then we rushed right out of the apartment.
And straight to the vet. We
vet.
texted the landlord, Michaela, that her father's dog attacked
Do you have the
ours.
vet report?
Yes. It's going to be in this pile.
How old is your pit bull?
4 years.
Okay. These are extensive medical records.
Those are the records for every appointment that we've had, follow-up since the attack.
And what was the total vet bill for your dog?
With the vet bills, the medication cost, it comes to $4,841.
According to what I read, you and your husband made a GoFundMe page.
That was after we tried contacting Michael.
Whatever it is you did, I just want to find out whether you received any funds from the GoFundMe page.
From the GoFundMe, we received $626.32 after the GoFundMe fees were assessed. This is money that people donated to us. They should not be responsible for those.
Just a second. Don't tell me what they should be. I'm just asking you. Made a GoFundMe page and asked for help in paying these vet bills, and you managed to collect $626 from, or a little bit more, from good-natured people who understood that this was a big bill for you, people that you didn't know. Unless your daughter is a really poor judge of character. You're saying that she is?
Yes,
Just
I
a
am.
second. Just a second. Are you saying that she is?
Yes, Your Honor, yes, I am.
Well, that's a slap in the face to your daughter.
I'll
take it. I'll take it.
Oh for vet bills after their Chihuahua was attacked by Michael's pit bull.
Now, let's start with this. You do understand that I understand that all these dogs were out, unleashed, and unmonitored. That a fair statement?
Aside from our dog.
Just a second. Your dog was unleashed and was roaming freely around the backyard.
No, he never got to that point. He got off the steps and was attacked by Michael's pit bull.
Well, you don't know that because you didn't see it.
Well, that is what happened.
That's what I heard
But
from behind the door.
That's what I was saying.
And he was physically there.
So what you're saying is the dog never got beyond
The 2-step.
it was at the bottom of the 2 steps.
Correct.
Okay. In any case, your dog was a visiting dog.
Yes, Your Honor.
And I'm just letting you know that you are responsible for these vet bills if I find that your dog caused injury to theirs.
Yes, Your Honor.
Do you understand?
Yes.
It would not be the same if it were your daughter's 2 dogs, because that was a risk that they assumed because the dogs had played outside in the backyard together, according to you.
Correct.
So if they got into a scuffle, that was sort of an assumption of the risk that a big dog can hurt a small dog.
Correct.
But your dog doesn't live there.
Yes, Your Honor.
They don't have to assume that you're visiting.
Correct, Your Honor.
And if you are visiting, you have a responsibility to keep your dog in check.
Yes, Your Honor.
Because you knew that they have a small dog. Your defense to this is that the incident never happened. That's what you wrote. Somebody want to stick up for that this incident never happened? That they took the dog immediately over to the vet after this incident, and that what the vet wrote in his report, that there was no weight bearing on one of the limbs because it had a compression as a result of being bitten or perhaps just picked up by your dog. So I'm ready to hear whoever wants to talk.
Your Honor, on the day that they say that this happened, okay, I was putting together a snap-together floor in my daughter's kitchen, okay? So there was no power tools being used. None of that stuff was being used, okay? It just, you pop it together and that's it. There's no noise, there's none of that. I didn't know that any of this even took place, all right? The door's open. I didn't hear anything. No yelping, no screaming, no nothing. You're talking about a 60-pound pit bull versus a 6-pound chihuahua. Her boyfriend comes downstairs. He says, hey, Jason just called me and said, Mello bit Kendrick. I was like, what? I said, get out of here. I thought he was playing with me. I literally thought he was playing with me.
Where was your daughter?
I was upstairs.
She was upstairs.
Your daughter was upstairs.
Yes.
You were downstairs.
Yes.
What was the back door doing open?
For the dogs to roam in and out of the house.
At will, without bothering anybody to go out.
Correct. But what I'm saying is I heard nothing, no yelp, no anything.
Who cares what you heard? You know these people a long time. They were friends of your daughter's for a long time.
They've been in my house. They played with my dog.
Just a second. You know these people for a long time. They've been to your house. You've been to their house before this incident.
Yes, Your Honor.
For how many years?
Oh,
3, 4 maybe.
Almost 4.
3 or 4?
I've only known them for probably 2 or 3, but
2 or 3 years.
Yes.
Your daughter knew them well enough and liked them well enough to invite them and give them a family and friends discount to move into the house. She liked them. I would have assumed if she bought this house in 2020 that she would have not allowed people to move into her house, invited them to move into the house if she thought that they were liars or scammers or storytellers or looking to make a fast buck, unless your daughter is a really poor judge of character. You saying that she is?
Yes,
Just
I
a
am.
second. Just a second. Are you saying that she is?
Yes, Your Honor. Yes, I am.
Well, that's a slap in the face to your daughter.
I'll take it. I'll take it.
Okay, well, that's a slap in the face to your daughter. I want to tell you something. I don't care what you heard. What is common sense is that that's what happened. And the fact that you didn't hear it in the law doesn't mean a damn thing. Now, this happened in April?
Correct.
Of 2021.
Yes.
And they had been living in the house since November or December of 20?
Yep. December.
Yep is not an answer.
Your Honor.
Did they pay rent in December?
Yes, they did.
January?
Yes, they did.
February?
Yes, they did.
March?
Yes, they did.
April?
Yes, they did.
So they paid rent in April before this incident happened. Then they presented you with a vet bill. In what month did they present you with a vet bill?
They never presented us with any bill.
Did they ever discuss with you paying for the vet?
They called asking for our homeowner's insurance.
Not ours, your homeowner insurance.
Well, they asked both of us for our separate homeowner's insurance.
Well, he can't get homeowner's insurance if he owns a pit bull in all probability because they don't cover pit bulls on homeowners.
They make you in Rhode Island.
What?
Your Honor, in Rhode Island, they make you get a special type of insurance for vicious dogs if you own a home.
But her dogs aren't categorized as vicious dogs.
I'm not clear on that in the state of Rhode Island.
Are they? Do you know? The answer is you don't
do not know.
Okay. Could you look up, Sarah, just for my own information, pit bulls and Akitas, state of Rhode Island, homeowners insurance, see what you can find while I'm continuing with this anyway. Mr. Farias, I don't care whether you heard it or not. You're responsible for what happens with your dog. And if you let your father be there with his dog, you're the homeowner, you are likewise responsible. They asked you for your homeowner's insurance, and you said what when they asked you?
I said this never happened.
Okay, so you said this never happened?
Yes.
And you said the same thing?
Yes, Your Honor.
Okay, I'd like to see, other than your statement that I didn't hear anything, I'd like to see what evidence that you have. I heard the story, I read the vet report, and I read the vet information and follow-up. I'd like to see, other than your, I didn't hear anything, I'd like to see any evidence.
Well, Your Honor, we do have the police report here.
I'd like to see it.
Your Honor, pit bulls and Akitas are considered high risk in the state of Rhode Island for insurance purposes.
Thank you. Do you have homeowners insurance?
I do.
Do you have special insurance for the Akitas?
I'd have to look, but I didn't own my dogs at the time of purchasing the house.
Your Honor, that's a lie.
I didn't own.
Would you not interrupt again? Great. I'm telling you this now. You have 2 Akitas. They're on the list in Rhode Island. You have to advise your insurance company. Your rates will go up accordingly. Somebody is watching because somebody's going to tag this case and say, you know what? I live near her. Something happens with one of her dogs. She's vulnerable. I could own her house. It's a nice house. Do you understand?
Correct. Yes, I do.
Well, I would take care of it if I were you. That's not funny. It's not funny. Are you telling me that both you and your father are idiots? You own a home, you hired a lawyer, and what you're telling me is you paid the lawyer because there was a hearing, and you never asked for a copy of the papers?
Causing injuries to their dog after Michael's pit bull attacked their chihuahua.
Now, they paid December, January, February, March, and April's rent. You filed for an eviction when?
I started the process on June, and they were served.
June what?
June 8th was when they were served the.
Just a second.
July 8th.
July 8th. My apologies.
Who filed the papers?
My lawyer did.
So you hired a lawyer?
I did.
On what date?
So the date was May 21st of 2021.
So April's rent was paid, and in May, you filed for an eviction. Did you tender May's rent?
Yes.
In what form?
I believe it was a check issued directly from my bank to the defendant.
Is that the way you paid rent in December, January, February, March, and April? A direct bank check?
That's correct.
Did you receive direct bank checks from their bank for December, March, April?
Yes.
Was a check tendered to you from the bank in May?
Yes.
Did you cash it?
Yes.
So they paid May's rent?
They did.
You filed an eviction, May 21. May I see the papers that you filed? No, I want to see the papers that you filed.
So the constable would have given it to them.
No. You had a lawyer. Get me a copy.
Because of COVID, I never met the lawyer. It was all via telephone.
The lawyer sent you copies of the papers.
No, they did not. They sent it to the plaintiffs.
Are you telling me that both you and your father are idiots? You own a home, you hired a lawyer, and what you're telling me is you paid the lawyer because there was a hearing, and you never asked for a copy of the papers?
So I have the notice of termination of tenancy.
Yes.
I have it via email.
I want to see
I have
it.
a physical copy if you'd like.
And you can take her copy while you're there.
That's the original.
Well, this doesn't say the ground. This is a notice of termination of tenancy. What was the reason you were evicting them?
Just incident after incident, I just couldn't deal with the headache in the house anymore, so I went through the correct channels of doing the eviction legally.
Your Honor,
They're on a month.
I have proof that this was all in retaliation. I'd like to present to you.
May I see it, please?
This is a notice
Of
that
course
we
it was.
received
Of course it was.
from the defendant on May 4th, letting us know that our restrictions
Don't
were
speak.
no longer.
Don't speak. Did you go to trial on this case?
We went to court and the 2 lawyers settled.
Okay. Can I see the notice of settlement?
Yep, this is our carbon copy that we were provided.
You have any other documentation from the housing court?
I do not know.
Okay, so the rent and use occupancy damages to be determined at a later date. Execution of the notice of eviction is stayed until October 1st.
That's correct.
That was the decision of the court. Did you pay rent in July?
Yes.
June, of course.
That is correct.
August?
That is correct.
You accepted the rent?
No, I'd never received any drafted checks after June.
I have proof of
May
all
was the
3
last
payments
check
were
that I
issued.
cashed.
After June, may I see your bank statement, please?
So these are 2 carbon copies of the checks for July and August, and the first 2 are the proof of the FedEx UPS check for July. The carbon copies are for August and September.
So I'm going to tell you this. I think that she did, in fact, file notice of eviction in retaliation for this incident. You're requesting $4,800, which is a difference of $600 for filing this eviction process. And I'm going to grant you $4,800 with one caveat. I'm going to say to you that this is a small property. And it would seem to me that the two of you would try very hard to extricate yourself from the defendant's home and find another place to live. Have you been looking?
We already have a place secured.
Great. And when does that start?
October 1st. We're moving out September 30th from the location we're at now.
Very good. All right. Because I don't see people living under these circumstances in a house where you used to be friends, you no longer friends, actually, less than friends. So I'm very glad that you found someplace else to live. Judgment for the plaintiff in the amount of $4,800. We're done. Thank you.
Court is adjourned.
First off, that dog was a rescue dog. It already had injuries.
Dog was never injured. Never injured. He actually came from a family of ours, like family members.
They don't tell you in a vet report whether they're old injuries or new injuries. The dog just had injury.
Neither of them like to take responsibility for their own actions.
They love to lie.
We're not saying that there wasn't nothing wrong with the dog. There was already something wrong with the dog because it was a rescue dog.
It brought tears to my eyes. It's like a child to us. So our dog is our child.
And the way he comes off, he could have injured the dog coming out because not earlier in that day, he backed into my daughter's car, so we thought she was going to go after him anyway.
No.
We came close to their car. Never exactly stopped.
Yeah, good riddance. That's the best you can go at it.
He'll always have an issue now going forward, but he's still our rambunctious little boy.
So when I looked at that list of high-risk dogs for you, I was surprised by some of the dogs that were on the high-risk list for insurance companies. And even beyond that, I didn't know that if you have one of these high-risk dogs, which I think might be different for every state, and you don't disclose that to your insurance company, if a situation like this happens, your insurance will deny your claim. So it's really important that people, if they have any breed of dog, really, just to check the list to make sure they're not failing to disclose to their insurance company.
Because if a freak accident happens, you
They're
may
not
lose your
covered.
house. You'll lose your house.
Yeah, risky business.
Yeah. Be aware, accident looking to happen. This piece flew off and damaged their car.
I can't recall.
Actually, we took a picture.
I can't confirm or deny that I was there.
You can see him driving.
This is Judy Justice.
Come to order. All rise.
Be seated, please.
Hello, Judge. Case number 1145, Fellows versus Mock.
Thank you, Kevin.
You're welcome.
Mr. Mock, what kind of business do you have, sir?
I do power washing and leaf blowing bag as well as snow blowing.
Do you have a regular car or a van that you use?
I have a truck.
And you have signs on your truck.
Yes.
And on April 9th, 2021, you had signs on your truck that were magnetic?
I don't recall. At that time, I may have. But since then, I have went to stickers. So
Okay, but you did have magnetic signs on your truck.
at some point, yes.
And you had those signs on both sides of your truck?
Correct.
How large are they?
Say about 18 by 12 inches.
And those signs say the name of your business?
Correct.
And they say the telephone number, how to contact you?
Correct.
So you're advertising.
Correct.
Do you remember the date in April when this incident happened?
According to
them.
I don't.
You don't.
No.
But do you remember at some point on or about April 9th, you checked and you were missing one of your magnetic signs?
At some point in April, yes.
And that's because, according to Mr. and Mrs. Fellows, they're driving along, and one of those magnetic signs from your car went flying off your car and hit the mirror of their car, damaged their mirror. They want you to pay for the mirror. That's what this whole Geschichte is about, right? And they don't look like crazy people, and you don't look like a crazy person. So at some point, what they did, according to their complaint, Mr. Mock, is they drove up, because they're on a highway, and they drove up next to your car, and they wrote down the number from the magnet that hadn't flown off. So far, correct?
Actually, we took a picture.
Took a picture. Great.
He had a
Can I
magnet
see it,
on
please?
The other side, too. Yes.
Yeah, great. Photograph makes it so much easier. I got it. This is your sign, sir?
Yes.
Great.
And you can see him in the picture as well.
Yes. Got it.
Okay.
Okay? And so that's how they got your information.
Okay.
And then they called you.
Not immediately, no. But at some point, they did make contact with me.
Okay. And after you say that you were startled by something flying off and hitting the mirror, which could have been much more dangerous. These things that clearly then dangerous. Everybody should be on alert. They can fly off. Be aware. Accident looking to happen. You examined your car, and what did you find?
We found that there was a piece on the mirror that was broken. I have a picture of that as well.
I'd like to see it.
And I would like to say the reason we didn't call right away when I have a chance, Judge.
Sure.
You can see the magnet that's stuck in the mirror there.
Oh, gee whiz.
Your Honor, may I see those
Absolutely. Absolutely.
And we had emailed these to the defendant, Your Honor.
Did you ever see them?
And we exchanged emails as far as that goes. I actually seen the picture of me, but I did not see the other ones. And as I was attempting to receive counsel myself, as far as those goes, I asked them to
That's your sign in the mirror.
And we actually have the sign.
That's a piece.
We have the piece of the sign as well.
Oh, Kevin,
So I
would you-
asked them to send me these
just
pictures.
a second. Would you show that to Mr. Mock while you're there so you don't have to make 2 trips? Got it?
Yep.
Okay. So you see, they come prepared.
Right.
Great. So these are the photographs of your sign in their window. This is clearly your sign.
It looks like it.
You can see the little tree
I
that's
ju-
matched to the
I-
picture.
I see it. Of course he sees it. Okay. And how much is it going to cost to fix the mirror? He's responsible for that. He knows that.
Written estimate we finally received from the dealership where I bought the car was $726.11. I have an estimate. If
May I
could-
see?
And I also do have a reason that we had an initial different price, so it was kind of a long saga.
And what year car is it?
It's a 2020 Subaru Crosstrek, my very first brand new car I ever bought.
Right, our mirror assembly, glass, and trim.
Which it has the blind spot sensor in the mirror.
Yeah.
That's why it's so expensive.
You're entitled to have a perfect mirror. You don't have to have it fixed and polished up. It's a brand new car. Okay, now you're going to tell me why you waited and why you gave him a lower estimate.
So when it first happened, of course, we didn't know. We're driving, 65 miles an hour on the
We're
freeway.
past that already.
So we didn't know
we
if there
have
was
we
damage.
have confirmed liability.
Okay.
Do you understand that? We have confirmed liability. This came off of your car. You're liable. Period.
Based on the dates that they gave you, I can't confirm or deny that.
Just a second.
That I was there.
You don't have to confirm or deny.
what date they
That's
gave.
what I'm here for. That's what they pay me all this money for.
Right.
I'm telling you, there are 2 parts of a civil case, whether you're responsible for something, and if you are responsible for it, what the damages are. That's the 2 parts of a civil case. They've already, in my judgment, met their burden to show that on the 9th of April, this piece from your car on the other side flew off and damaged their car. So liability is finished.
I have something to say. So April 9th, can you ask them to confirm at what time? Because I'm a school teacher as well, so I own my own
Listen
business.
to me. You're in the car, sir. You're in the car.
Right. So my magnet did fall off the car, but that doesn't necessarily state that my magnet came in contact with their car, and that's just not. I mean, I don't.
Mr. Mack,
think
I
that's
don't
enough.
care what you think. If you're a school teacher, I'm worried for the kids. I've explained it to you very carefully, Mr. Mack. I've explained it to you. This plus this plus this establishes your liability. Period. The only question is damages. Now, in this case, the car is a new car. If the mirror was at all damaged, they're entitled to have a new mirror.
And which I tried to do.
Just a second.
Okay, go ahead.
So what I've said to you is 2 parts, liability, damages. How do I know for sure it was your sign that came off your car that they retrieved from their mirror that looks exactly like your sign on April 9th? How do I know that? I know that because it's common sense. And the law is not supposed to be an ass. Teach that to your children.
I try. Thank you.
Okay? So the question is one of damages. Now, you were going to tell me, Ms. Fellows, without any drama and without any hearsay, why it took you time to call him.
Okay.
And why you initially gave him a lower estimate.
Okay, we were on our way to our church meeting, so when we got there, we saw the damage. So the next day, we called Jermaine Subaru, and my husband tried to explain over the phone what the part was. At that time, the person thought that they
Don't
knew.
tell me, you see, now you're telling me hearsay.
Okay.
And you can't,
they said it's
you can't do that.
$20.
You can't
But I'm
do
just
that.
trying to explain why with the hesitation.
Okay.
So they of
So
course
he
said
had
it was a
just a
$20
second.
part.
You keep trying to talk faster to me, Miss Fellows. But what I'm telling you is, whether you talk faster or not, I'm not paying attention to what you're saying that involves hearsay.
All right.
Now, if what you're telling me is that the first time you took the car into Jermaine Subaru, which is where you purchased the car, and they gave you this estimate, was the first written estimate that you got, I accept that. Don't tell me. My husband spoke to somebody on the phone. They described what the problem was. They gave him an estimate of. You can't do that. Okay. That's hearsay.
Okay.
So the next day you took it into Jermaine Subaru, okay, and you called the defendant. So that would have been the 10th or 11th.
The first time we called him, I left him a very detailed message. And
What
he did
date?
Not, he
What
never
date?
called me back.
What date?
April 10th.
Did you not call her back?
I did not receive a phone call nor a voicemail from her.
Okay, then I don't have to deal any further with this case, sir. No. Then you have to pay for new mirror $726.11.
Now, after that, we did have a conversation over the phone.
Okay, well, after that, let's be clear. She said she left you a detailed message. Mm-hmm. Whether you received that message and decided to blow it off, I don't know. But I guarantee you that the next communication she initiated.
Yes, Your Honor.
Right?
Correct.
Mm-hmm. Right. And the next communication, you did answer the phone or you called her back?
No, I answered the phone. I believe so, right?
Yes.
Yeah.
Yes.
Yeah. Mm-hmm.
And the two of you spoke.
Right.
Is that when she gave you a lower estimate?
I don't recall, but she did give me details about her taking pictures and.
Did she tell you she took the car into Jermaine?
I can't recall, but.
Then I'm going to go back to what I said 5 minutes ago. Judgment for the plaintiff in the amount of $726.11.
Ma'am.
Thank you, Your Honor.
The first initial estimate was $240.
We're done. We're done, Mr. Mark. We're finished. Do you understand? Do you understand? Two things. Just pay attention. And what you have to teach your students, if you're a teacher, is when something happens that is more your fault than somebody else's fault, what you're supposed to do is take responsibility, not stand here and say, well, I'm not 100% sure that it was the 9th. Where did I have the decals? And I'm not exactly sure. And then she calls you, leaves you a detailed message. You don't call her back. She has a repair estimate from Jermaine. They are a reputable.
May I see that?
Absolutely.
And I've tried to call this guy, and he hasn't returned my phone calls.
I don't know whether that's true or not, and I don't care. You told her that the name of your business was Inner Movement Wellness, a professional corporation.
Okay, I told her I needed an expert to help me because it was very
no.
Vehicle.
Now, all you have to do, sir, is either you have an expert here or you have for me something that is the cost price of a new mirror for a 2020 Subaru automobile. I don't have to have that evidence. You did. And if you want to dispute this, do it. You can't tell me I tried to call him, he didn't call you back. That's ridiculous. We're done here, Mr. Mock. It's a ridiculous. It's ridiculous. You are taking a ridiculous position. We're finished.
Court is adjourned.
Outside.
With the one we got over the phone, the person didn't understand what part we were talking about.
It went from $20 to $240 to $250.
And so then they gave the cost for just the part. The final estimate was for the parts and labor, everything.
It's like a $500 difference between the two estimates. So.
And we wouldn't have had to go that far if I didn't have to take him to court and get that evidence.
This is the first time I've ever seen those pictures. So if that would have been the case back then.
It really was his. I mean, we took the picture. You can see him in the car when we took the picture.
I definitely would have took the responsibility and accepted the fact that that my magnet did that damage.
And we were not trying to inflate the cost or anything like that. It was just an honest thing of going back to the dealership and getting that complete estimate.
So that case reminded me of a lesson I learned from my father, which was if it's more your fault than my fault, just take ownership, take responsibility. And that came after I got into an accident on the highway where someone hit my car. And I came home and said to Dad, Dad, it wasn't my fault. It wasn't my fault. And he said, hold on, hold on. Is it more your fault than my fault? Because I was at home watching a movie. So would you say that I have to deal with this or you have to deal with this? And I said, you know what, you're right. And I think this is a good case of that, is even if it's not your fault, not your intention, you still need to take responsibility.
It may not be your intention, but the damage was your fault. You chose to put on these magnets instead of decals, but they can be dangerous. And if they damage somebody else's property, like here, there's no question of liability. Yeah. The question was damages. And it's a brand new car. They're entitled to have a brand new mirror.
I agree.
That's it. Your father's right.
Case number 1147, Sanchez versus Sharif. All parties, please step forward.
Veronica Sanchez is suing tax preparer Darlene Sharif for the cost of legal document services and the loss of revenue.
Ms. Sanchez, what kind of business were you starting?
I was purchasing a chiropractic and acupuncture business.
Were you purchasing it from someone who had an existing practice?
Correct. The existing practice was a chiropractor, and I am an acupuncturist, so I had to purchase it from a chiropractor.
And was the chiropractor retiring?
Chiropractor was leaving the state.
So in effect, you were taking over his lease?
No, because since I'm an acupuncturist and they're a chiro, I did not purchase the business. I was purchasing the goodwill, so I started a brand new lease.
What was the name of the business?
Her business was called Inner Movement Wellness, a chiropractic corporation.
How much did you pay her for the name Inner Movement Wellness?
I paid $220,000.
And you signed a new lease with the landlord?
Correct. I have the lease, yes.
Just a second.
But now instead of Inner Movement Wellness, a chiropractic, it's Inner Movement Wellness and Acupuncture, a professional corporation.
Were you represented by an attorney in this $220,000
yes.
negotiation?
Yes.
And the name of that attorney was what?
Lee.
How much did you pay Mr. Lee?
We together paid him $6,000.
When?
June 7th.
Of this year?
Correct.
And you signed the lease when?
June 1st.
Now, you retained the defendant to file papers for you so that you could start to do business as Inner Movement Wellness, only you had to change it to an acupuncture. Is it a corporation or an LLC?
The acupuncture board says it has to say a professional corporation.
Okay. And when you hire the defendant, she's not a lawyer, she just prepares papers.
Well, she had done my son's nonprofit.
You know, she was not a lawyer.
Correct.
Mr. Lee was your lawyer.
Correct.
So she was supposed to file to get papers for you so that you could start your business.
So I can open up a bank account and start my business, yes.
On what date did you make initial contact with her?
On or about May 3rd or 4th, but I went into her office on May 7th.
Okay, this is what your case is about. We're going to go step by step. Went into her office on May 7th. You signed the lease on June 1st.
Correct.
You say the paperwork, because of her negligence, was delayed several months so that you paid rent for June and July. Did you ever get the paperwork from the state?
Yes, I did.
On what date?
June 30th, I received a workable S-Corp, but to this date, I don't have a DBA. To this date.
Just a second. So her work got you the paperwork that you needed to work by June 30th.
But she had promised to expedite it.
Okay, she promised to expedite it, madam. It's COVID. Nobody is working. You can't even get a license plate. Well, so what you're suing for is the return of what you paid her, right? Despite the fact that you got your paperwork, and for your potential lost income for a month.
Actually, I'm only asking for just 3 days, not the whole month of June.
She's not paying you for that.
Okay.
Just understand this. She's not paying you for your potential lost income.
Well, I paid 3 times the normal going rate. My accountant was going to do it for $800.
Listen, you can't tell me what your accountant was going to do it for.
Well, no, it's the going rate.
Just a second. And you can't tell me what the going rate is. You don't have experts here.
I Googled
it. I don't care what you Googled. What I'm telling you is, if you can establish some sort of negligence on her part, and it has to be a serious negligence, most you can get is some sort of a refund from her.
Well, I tried to ask for one.
Don't speak. Just listen. Because she got you what you asked for. She got you the ability to work. in a business in a relatively short period of time. Now, the only thing that I want you to show me is you filled out paperwork on May 7th. I would like to see the paperwork that you filled out with her in the office because you say that because of her negligence, that paperwork came back once.
It came back 3 times.
Or it came back 3 times. So let me see what you filled out the first time. No, don't give me 3 letters. I want to see what you filled out with her. May I see that, please? So you went to her office and you told her that the name of your business was Inner Movement Wellness, a professional corporation. That's what...
Okay, I told her I needed an expert to help me because this was very
No. It went directly to Ms. Sanchez.
Yes, it did.
And well, can I see it? Does somebody have it?
I do have this, but since she was going through a third-party LegalZoom, which I could have done myself.
Listen, you have to understand something. I don't care.
Several mistakes.
Now, you have to understand, this is what it's all about. You tell her what the name of your business is.
But if, but if she's an expert and is supposed to be able to help somebody who doesn't know anything about this, she's also supposed to guide me, and she didn't guide me correctly.
So, Ms. Sanchez, you told her that the name of your business, because you bought for $220,000, Inner Movement Wellness, a professional corporation.
And I also...
Actually, just a second. Actually, what I find fascinating is you bought the goodwill of a chiropractor who had been in the same location, and you bought that goodwill, and the chiropractor did not have an acupuncturist there.
There is an acupuncturist there.
Did that acupuncturist come with you?
The acupuncturist continues to work there, yes.
With you?
Yes.
How many people work there?
I have 11 employees.
How many did you bring with you?
None.
They were all there?
Yes.
Now I got it. So, Ms. Sharif, did you get anything back from the state with regard to this application?
For the fictitious business name?
Yes.
No, it goes directly to my client.
It went directly to Ms. Sanchez?
Yes, it did. And
well, can I see it? Does somebody have it? Did they not accept it? What is the current name of the company?
To answer your question to the best of my ability, on June 30th, I did get the S Corp, and I do have this, but since she was going through a third-party LegalZoom, which I could have done myself.
Listen, you have to understand something. I don't care.
Okay.
If what she went through was LegalZoom or any other app that gives lay people an opportunity to fill out paperwork, and if she decides to be an intermediary between you and LegalZoom or you and somebody else, that's her business. And if after it's all over you say, well, I could have filled out the same paperwork, so I want my money back, that doesn't happen.
No, but
that doesn't happen.
That's not why
I don't know what you want. You filled out these papers, and you have to show me where she did something wrong. Seems to me somebody who's paying $220,000 for a practice keeps the same lawyer. If they want a lawyer, if you want to do it on the cheap, you do it on the cheap. How much did she charge you for this?
She charged well above and beyond.
Don't chatter.
$2,600.
Okay, so she charged you almost half of that to get you the paperwork to operate as a business. That sounds penny wise and pound foolish to me. And the reason I'm short with you is you got what you paid for. You got the paperwork. And if my feeling is correct, it may not be, you're annoyed because you could have done the same thing through LegalZoom.
That's not why.
Now I'm going to see.
That's not why. It's because she promised expedited service, and it took months.
No, it didn't take months. Because once you fill it out and file it, somebody's got to look at it. Now let me see the first letter. No, don't give me 3 pieces of paper. Give me the first letter that you got from them, which is what she said you got. And initially you said you did not. Okay, so you have to understand, this came to you on June 1st, which means it took somebody in Los Angeles County, because this was sent in right away.
Right.
It took them almost a month to read it and respond to you. That's just a second. Just a second. That's not her fault.
No, I agree.
No. Great.
But had she done it right, had that been right, I could have started then right there.
Shoulda, woulda, coulda. If my parents had been taller, I may have been taller than 5 feet tall. That's a possibility.
And she
my
also-
brother is 5'9". I could have been 5'9", and he could have been 5 foot tall. That's a shoulda, woulda, coulda.
But also to promise expedited service when somebody's like struggling to purchase a business and keep things going.
Ms. Sanchez, you have absolutely no case. You were up and running for business on June 30th, according to you. Is that correct?
Yes.
Now, the thing that you don't have is a DBA, which you have not received yet. Well, so far you have something pending with the Department of State, I assume, and
Yes.
that's doing business as.
Yes.
Listen, I'm going to tell you this. If you hire somebody else and they're able to, during this time when people are not in state offices, if you hire somebody else to get your DBA and pay them, you're free to come back to me and say, she was supposed to get me the DBA, and she didn't. For whatever reason, I had to hire somebody else and pay them. Then I'll talk to you.
Okay.
Right now, she has paid to get you up and running in your business. You have 11 employees who have been working for you for almost 4 months. As a result of this work that she did, she got you what you needed
But
to
not
conduct your
timely.
business.
But it wasn't timely.
Goodbye.
It wasn't
We're done.
complete.
Court is adjourned.
It's just unfortunate during these COVID times when mom and pops are trying to do their best.
Tell you, I really, really worked hard on her case.
That we still have people that want to take advantage and charge high prices.
But she just was very persistent and
overcharge and underdeliver.
I'm sorry that she's unhappy.
And waste people's time.
Judy Justice, she did me well.
You know, I actually came away with two things. I think that the plaintiff was unreasonable. The process was completed enabling her to work in less than 60 days. That would be a reasonable period of time, even if it wasn't for COVID. The defendant enabled her through her work, nobody else's work, to hire, employ, and make a living within 7 weeks of their meeting.
Yeah, almost impressive during COVID that it got done.
Almost
that quickly.
impressive. So she's being unreasonable. And I honestly believe that her issue was that she could have done the same thing and filled out the same forms as the defendant did for probably $200. And the defendant charged her either $2,400 or $2,600. So she felt as if she was being scammed because she could have done it herself. Well, that's on you.
Yeah, that's something you want to look into before you
Engage
with someone
somebody
for their services.
Right. And she knew she wasn't a lawyer because, according to her, she had done work for the family before. I was unsympathetic.
I could tell.